You're now intimidating me, and you're threatening to kill me in this courtroom by having these armed guards that all you have to do is say, shoot this person down, and they're going to shoot me down in this courtroom because I dare bring the truth in? By making this issue and having it put on the record, the judge has just now been put on notice. We, the people, should not have to go to this extreme in order to defend ourselves, but they have pushed this to that point. We have people that are sitting back and complaining. The moment we file the paperwork in, a judge dismisses the paperwork. Don't worry about it. He can't dismiss it because of what we brought up here just a few minutes ago of the 1933 document, the 1945 document, the Title 8 of the United States Code, the Title 22 of the United States Code. This judge has to get you off point. This judge has to sit here and try to get you to panic, to get you to back down. This is why with this thing of the Coram Nobis and the Coram non juda, you only have two major things to do in that courtroom. That's it, two. One, stay on point. No matter what that judge does to you, you stay on point. No matter what he says, you stay on point. And that point is jurisdiction. Now, this judge has got to sit down and tell you, well, I was appointed by the Supreme Court of this state, and that gives me jurisdiction. It's no, sir, it does not give you jurisdiction. What the Supreme Court did was allow you to be able to sit on this bench through the court system by agreeing that you could be a judge. That doesn't give you jurisdiction. I'll go back and tell you, well, the people elected me. That gives me jurisdiction. No, sir, being elected only gives you a job. And seeing how you made the issue that the people elected you, then what you're telling me is that I can fire you right here, right now, today. You're fired. Because if you're going to make the issue that you were elected by me, then I can fire you. And you're fired. Get off the bench. So don't tell me that being elected gives you jurisdiction. It tells me that you're an employee of mine and I can fire you. If they bring up the issue, well, do you have a driver's license? Do you vote? Do you have marriage license? This, again, does not give you jurisdiction, sir. All this does is sit down and allow me, if I have a driver's license, it gives me an address if something happens to me that someone can report to my family. The fact that I have a voter registration card does not give you jurisdiction. It allows me to put people like you in office or take people like you out of office. So don't sit here and fall into the traps and intimidation of these people when they start handing all these excuses. Because number one, it isn't up to the judge to set the jurisdiction. It's up to the accuser. Because if you go back in and start reading the complaint form, whenever you are the plaintiff, it asks you, what jurisdiction are you going to run this thing into? What's the foundation? What is your argument? You have to set the jurisdiction. That now means the accuser has to set the jurisdiction, not the judge. But this is where we've been making our mistakes. We've been allowing this judge way too much power, and this is what the Bar Association has been doing, allowing him to make all these determinations. It has never been by the attorney bringing the charges, because the attorney can't bring the charges because it's hearsay. That's why they can't set jurisdiction, because it's hearsay. This is why the courts are running away with this. This is why we've got to stand fast on what we're doing. That's why there's only two things that you have to do in this courtroom. Stay on point and stay on jurisdiction, and don't let them get you off jurisdiction. Now, this judge may sit here and say, well, let's get by this here a little bit. We've got some other issues. He says, no, sir, until jurisdiction is set by the accuser, you cannot move any further. This falls back under the Code of Civil Procedure under Chapter 5, under Rule 418.10. You have personal jurisdiction. You have personal persona in that courtroom. Until the proper venue and jurisdiction is set, that court can't move. And now that we know that they're operating under foreign sovereign immunity, that court cannot proceed under foreign sovereign immunity. and they will never admit this. People are panicking because judges aren't following the rules. They're going to try to sit down and sidestep this every which way they can. That's why you have to stand fast, stay calm, and argue this. Like I said, the judges are going to do one of two things here. He's either going to dismiss this, or he's blatantly going to break the law. These are only two choices he has. Now, we have developed several different things for paperwork. What we're coming up with. One of the issues that we are dealing with is the allocation of jurisdiction. And this is where, in documents, of where the other side has to set jurisdiction. It's a requirement. They have to set it. They never do. And this is the foundation. This is what your objection to. Object. The other side has never sit down and declared jurisdiction. Stay on point. They've got 10 days to sit down to do this issue. And don't allow them to get off of it. Don't allow them to sidestep this thing. That's one of the first documents that you want to put in if you're going in for the first time. You're also going to file in the Coram Nobis. Like I said, that Coram Nobis goes in and explains that there's been an error made. With this Coram Nobis, you're going to file in also the following documents. You're going to file in the Coram Nobis Terrorist Act with your Coram Nobis. What this document does, it goes in and it makes the issue that it has come to my attention that all federal, congressional, and state legislative enactments, rules, regulations, or anything created by private corporations or associations, agencies, instrumentals, or entities that are defined under the judiciary and judicial procedure of Title 28, Section 3002, is being deemed by many administrators in this field as anti-government patriot laws. If anything that we have filed in has been declared patriot laws, they have deemed us to be militia, constitutionalists. They have deemed us to be KKK, neo-Nazis. Ladies and gentlemen, we aren't the ones that created all these codes, rules, regulations. All this stuff was either created by our elected officials, Congress, on the state side or the federal side, or it has been created by corporations that Congress made privately to go back in and create the rules, regulations, and guidelines. This is what they are deeming to be anti-government patriot law. So we're going to shove it right back on them. But we're also going to go back and make the issue under the H.R. 1955, which is the Homegrown Terrorist Act, and H.R. 3162, which is the Patriot Act, under Section 800. Section 800 goes into domestic terrorism. And under domestic terrorism, it sits here and goes into quite a bit of detail and quite lengthy of what is domestic terrorism. That by that judge or administrative officer, rather, by him bringing in armed guards into that courtroom, he has just now committed an act of terrorism against an American citizen. He has now made an aggressive move against you to intimidate you, to coerce you, to threaten you, to blackmail you, to intimidate you. If you don't agree with this man sitting on the bench, he's going to order these people to shoot you down in that courtroom. And that's exactly the mentality you need to run with when you're dealing with these people, because that's exactly what they're doing. The other thing that we have developed, you're going to file in with this, is also the non-slave owner. This goes back into September of 1850. We have discovered on September 18th, 1850, that this law was repealed. This goes back in for slave ownership. This is where the registration stuff comes in at. You registering your car, putting your deed up for your home, voter registrations, birth certificates, all this comes out of the Slave Act that was repealed in 1850. What they're doing, they're bringing you in as a slave owner. This is where that straw man deal comes in. This is your slave. You have to go back in and make the issue that I'm not a slave owner. These are the documents that you're going to put in. So you're going to put in the allocution of jurisdiction for your first hearing, that the accuser had never made the issue of what jurisdiction. The Coram Nobis you're going to put in. You're going to put in the Coram Nobis Terrorist Act and the Coram Nobis non-slave owner. And we have a entry of judgment that we can file with this in order to have the judge dismiss this because the accuser has failed to state jurisdiction on your case. Now, this Coram Nobis can be put in also if you've already had your hearing, you've already been convicted. I'll go back in and file this back in along with the Terrorist Act, along with non-slave owner, along with the entry of judgment to go back in and have the record corrected. The Coram non juda, if these first documents fail, the Coram non juda is going back in and now point blank telling the court, I put the Coram Nobis in to tell you that an error was made. You refuse to acknowledge this. Now the Coram non juda, now I'm telling you, you're not a judge. You have no authority and you have no jurisdiction and your order is void. This falls back under Rule 60 of the Federal Rules of Civil Procedure. Now you're point blank telling the judge they don't have. You gave him the opportunity to go back in and correct the record. He had every chance to sit down and do his job right, and he didn't do it. Now, with the Coram non juda, we've got several documents for it. You have the Coram non juda objection. This is where you start filing this in, and the objection goes into congressional records. You're now telling the court why they don't have that jurisdiction, because you're going back and explaining to them in 1933, under this 49 statute, under 3097, under Treaty Series 881, under Conventions and Duties of the State, that Congress relinquished all state statutes and put everything under international law. They point blank telling them, these are congressional records. This is what Congress did. This is why you don't have jurisdiction. This is why you don't have subject matter. That's why you don't have venue. That's why you're not a judge. That's why you don't have the authority, because Congress took it off of you. Also falls back under the International Organization Immunities Act of December 9th, 1945. You put this in also as evidence. Put it in as an exhibit or evidence, however you want to call it. Now you're going back and telling the court, in 1945, Congress relinquished your office and made this office under UN. You are no longer an American citizen. You now are a UN employee. You're also going to put in that International Reorganization Rescind Act, where the judge sat down and filed paperwork in and shows that the Rescind Act was never rescinded. The Supreme Court declined to hear this case, but this goes back in and explains where this judge has blatantly, point blank showed where Congress violated their constitutional position by relinquishing every single public office in all these states over to the UN for their total jurisdiction, for their total control. We're also going to file in with this document, Title 8, 1481, where they gave up their nationality. They gave up their citizenship the moment they took that oath of office. You're also going to go ahead and put in that Title 22, that CFR, under foreign agent. The accusers are now going to have to come back in and rebuttal this. They're going to have to come back in and make the issue, and they're going to have to prove that Congress never did any of this, and these statutes don't exist.